Everyone, thank you so much for being here. Welcome to another program from the Smith.ai Master Series. And I am Maddy Martin from Smith.ai. If you are not familiar with us, we are a 24/7 virtual receptionist service. We handle calls, chats, texts, Facebook messages, a whole lot more than just answering and message taking, but appointment scheduling, intake forms, payments, you name it, inbound and outbound. So learn more about us at Smith.ai. Right now, the topic of the day is hosted by Joey Vitale of Indie Law and many other ventures. Joey, in the years that we've known each other, I think you've added maybe at least one new venture a year, but you are well known and justifiably well recognized for your work in helping businesses protect their assets, in protecting their brand. And here we're going to learn today about what are those assets, what is worth protecting, what can you protect, and how does that protection happen? Things to be aware of and mindful of as you start to develop a bigger brand that might attract competitors, people who are going to try and encroach on your brand. So the topic today is how to protect your brand and get legally legit. I love that topic, and really focus on, challenges that every entrepreneur is facing. So without further ado, Joey, if you could introduce yourself and, let's get the presentation started.
Absolutely. Well, welcome everyone. Maddy, geez, everyone give it up for Maddy. Maddy is just the absolute best. And I use and love
Thanks,
Smith. It's such an honor to be here today. And I have been, I'll do more of an intro on myself later in the presentation when it kind of makes sense more after we clarify what it is that we're going to be talking about. But I love this topic of keeping businesses safe, specifically keeping brands safe. We are going to be talking about all kinds of legal stuff affecting businesses today, but really we're going to be focusing on trademarks and brand protection. So the subtitle of this is 3 big trademark mistakes to avoid so you don't lose your brand overnight. It's not I lost on me that an ambulance drove by making those sirens as we talk about this important topic. Everybody, just so you know, in terms of this webinar live software, I would love it. I have a very highly engaging presentation for you. So let's not be a stranger to that chat feature. If you do have any specific questions, however, please use that Q&A. I'll circle back to that Q&A section to answer your questions at the end of all of this. So just wanted to clarify that you're in the right place. If you've got a growing business and a big vision, which is true for everybody using Smith or thinking about using Smith.ai, if you've heard of trademarks before, but they're confusing to you, but you're committed to protecting your brand against big risks and you want one less thing to keep you up at night. Here's what you're going to learn from hanging out with us today. I'm going to deliver as much valuable education as I can in the next 30 to 45 minutes, plus some time for Q&A. You're all going to get actionable and practical tips, not just theory. I like to tell my clients that I went to law school so that you don't have to. So I'm not just going to be throwing the equivalent of a casebook at you. You're going to be able to walk away with some real next steps. My firm, Indie Law, has filed well over 500 trademark applications. So we really do know this stuff. Because of that, I ask that you be open to learning something new. There is a lot in the trademark world that goes against common sense, that goes against what we think is true when it comes to trademarks. So close out of other tabs, silence your phone, and get ready to take some notes. And there will be a chance to get all of these slides at the end of this training. But first, like I said earlier, we're going to be talking a lot about trademarks. But before we do that, I've got this action taker bonus that I would love for everyone to take advantage of at the end, a bunch of deeper dive resources that I have for you. We don't have time today to get into all of what you need to know about trademarks, but I have 2 very high value bonus resources that I'll share at the very end. No cost to you, you just have to stick with me through this training and I'll share that link for you. And I get it. legal stuff can be really confusing. I know that Smith.ai has a large number of lawyers that they work with. And if you're not a lawyer, I want to make sure this is true at the outset that I get it. Legal stuff can be confusing. And let's be honest, even if you're a lawyer, a law firm owner, the legal stuff and practices outside of your own can be confusing. Most people who I give this training to really relate to this slide. Like whenever we start throwing around a lot of legal terms, you just want to stick your head in the sand. Don't worry, I got you. I promise to keep all legalese in this training to an absolute minimum. And by the way, I love that everyone's introducing themselves in the chat. Keep that up as well. I'm going to do my best to juggle these slides and the chat. Let's see. Oopsies. Sorry, you guys. Okay, so a quick poll. How would you rate your knowledge of trademarks? Give me a 1 in the chat if you feel pretty new to trademarks and what they mean. Give me a number 2 in the chat if you feel like you kind of understand trademarks. Give me a 3 if you feel like you are a trademark ninja. Let me know where you're at in the chat. Okay, I'm getting some 1s, I'm getting some 2s. It's also great just to make sure that this chat feature is working for everyone. So let's zoom out while we're waiting for those chat responses to come in. I want to talk really broadly, big picture level about your business needs. Because at the end of the day, everything that your business needs in order to thrive exists in one of these 4 boxes. Number 1, you need a brand. When I say brand, I mean you need something that is distinctive in the marketplace. What is it about your brand that makes people want to work with you specifically and not your competitors? When I like to think of it as, when people walk down that cereal aisle version of your industry, what makes them choose your box of cereal and not the Cheerios right next to it? Then we've all got separation. If I can get a little woo-woo for a second here, I want to be clear that one of my big mindsets around business ownership is that you are not your business. And no matter how good or bad your business is doing right now, that does not define your sense of self-worth as a human being. And it's really, really important for us to grow our businesses, for us to not feel like our sense of self-worth, our sense of value is tied to the business. And usually, the more that we can let that go, the easier it is for our business to grow and be managed. The third box is relationships. We've got all kinds of relationships that we have to manage in our business, whether that's clients and customers, or our teammates, or collaborators, referral partners that we work with. That's a big box that Smith.ai can help you with in terms of the people calling your office, going to your website. And then when it comes to content, that is all of the stuff that you have to put out there in the world to make sure that people know that you exist. Everything from social media to your website, maybe you're writing a book or working on a podcast, all of those things. I'm talking about business in this way because sometimes people like to think, okay, Joey, you're a lawyer, you're a business lawyer, you help us with this kind of 5th box that we need to work on for our business. The truth is that there is no other legal box, but rather there's a legal counterpart to every one of these 4 boxes. So when we come to brand, that's where trademarks come into place. Again, trademarks protect things like your business name, logo, slogan. That separation is really important. We talked mentally about that importance of you not being your business, but if you're still a sole proprietor, then technically and legally you are your business. And it can be really hard to run your business when legally you know that separation isn't there, which in my opinion is one of the main reasons to get an LLC or a corporation outside of that personal asset protection. Third, when it comes to relationships, that's where you have all of these different contracts that you have to manage. And then finally, copyrights govern content. A lot of times people want to ask me in this training, Joey, can you tell us more about this difference between trademarks and copyrights? Well, we're looking at the main answer here. Copyrights protect content, whereas trademarks protect your brand. If you guys have more questions about that, I'm happy to circle back to that in the end. Let me know in the Q&A section. But I've got a serious question to go from here. It's not really too serious. I want to know who everyone's favorite Marvel character is, or just superhero. I was talking recently with someone on Facebook. I started this poll of, do people like Star Wars or Marvel more? And it was crazy to me how much everybody said Marvel. I think there was maybe one vote out of more than 20 people that actually said Star Wars. So Marvel is getting really popular right now. I know that ever since COVID, I've gotten into everything. Maddy says Spider-Man. I know I'm partial to Spider-Man as well. But let us know who your favorite superhero is. Ooh, Marvel Black Panther, Mickey Mouse, love it. Ooh, Moon Knight, deep cut from Scott. So I want everyone to imagine this. Imagine if your favorite actor in Marvel or elsewhere legitimately gave your business a shout out on social media. Think about how much viral attention your business would be if it got a shout out like that. And on that note, let's play a little game, have a friendly little competition. Let's say the winner of this competition gets $50,000. And this goes to, if all of us got that type of a shout out, which one of us would be the business owner most prepared for rapid growth? Because we talk all the time about, oh, I would love to go viral. I would love for my marketing to be better. But you have to be careful what you wish for, because when you get that much attention on your business overnight, that can really create some problems on the back end. Both you can have a lot of new clients that now you have to suddenly take care of, but also the copycats notice and will probably want to start to copy what your business is doing. So again, if we all put ourselves in that shoes of immediate, overnight, viral attention on our businesses, how would you feel as a business owner? You might feel like my friend Taylor. I call her the swamped entrepreneur. She's busy with all the other parts of her business and hasn't really thought to make trademarks a priority yet. And now she's realizing that she's just duct taped together a brand protection strategy up to this point and doesn't really feel safe. She's never secured any trademark rights and is just crossing her fingers that this brand that she's been building isn't already taken by someone else. And she's worried about copycats stealing her stuff and stresses about others profiting her work. Let's contrast that with my friend Lindsay, the legally legit CEO. We can tell by the flower crown that we like her already. So Lindsay has proactively applied for trademarks to secure her business name, her logo, and her other big brand assets. She doesn't freak out when she gets viral attention, but instead reviews her enforcement plans and updates her team on the great news. She goes to bed easy at night, knowing that her brand isn't at risk of being stolen or taken away from her. And she's ready to handle those copycat situations objectively and confidently without being seen as a bully or a doormat. A question for all of you: who would you be if your business suddenly went viral? Option 1 or option 2? Let me know in the chat, just the number 1 or the number 2. It's okay, we can all be honest here. Rick says 1.5, that's a good answer. 1. Okay, I'm seeing some ones come through. I'm highlighting all of this because I want to make sure that I am really clear on this next point. The real talk is that most entrepreneurs can identify with option 1 here. They can identify with Taylor. And I can tell you that because as an attorney who promises client confidentiality, I can't tell you how many times I've been on the phone with business owners who tell me those deep, dark secrets about what's going on behind the curtains that they don't tell everybody else, that you don't see on their social media. And I can tell you that most business owners feel this way, like they just don't have all of their legal ducks in a row, and that's okay. So I just want you to know that you're not alone if you could relate to number 1 here. I should say, again, this is a presentation brought to you by my team at Indie Law. We help Taylors become Lindsay's. We help you become that legally legit CEO. We're not really your average law firm. One of the big things that makes us different is as a team, we don't really like arguing. just to argue. We're a group of peacemakers. Maddy, yes, not Karens. We do love entrepreneurs working with people just like you, and trademarks are our jam. Trademarks are all that we do. It didn't used to be that way, but now we're an exclusively IP and trademark firm. And we made that pivot to our law firm because of this. As business owners, we don't know what we don't know. And the truth is that not all legal problems are created equal. After years of being a law firm that provided all kinds of legal services to business owners, we saw time and time again that practically speaking, our clients were most likely to get blindsided by trademark problems specifically. And we'll dive into why during this training. So after years of being a general business law firm, doing things like contracts, entity formations, and all kinds of IP work, we as a team had our light bulb moment. And we rebranded to become a trademark-only law firm. Indie Law, the trademark firm, was born. And you can see a nod there to our slogan that we put the rad in trademarks. I'll get back to what that means later in the training. But once we made this transition, we started to see that our reviews were going up. I loved on social media seeing these trademark registration selfies that our clients were sending us after they got their trademarks. But I'm getting ahead of myself. We're here because business owners are making 3 big mistakes that put their brand in danger. Mistake number 1 is, I don't need a trademark because I already have a fill in the blank. Maybe it's because you have an LLC or a corporation or something like a professional corporation in that name, or you've already got the website, or you've grabbed those social media handles. This is something that we hear quite a bit. Give me a 1 if you've either thought this before or someone's told you this before, that you don't need a trademark because you already have one of these things. Just give me a 1 in the chat. Rick says, nope. Okay, that's good. All right. So let's talk about what a trademark actually is. Because as we've talked about, trademarks protect things like business names, logos, slogans. It could protect an online course, a podcast, a product line, things like a signature method. I could give you the legal definition of a trademark, but it's not very helpful. The truth is that we all know kind of what a trademark is. It's kind of all a part of pop culture. Like if I were to tell you that Nike, McDonald's, and Target all have trademarks, I think we can all kind of nod along and say that makes sense. So what I'd like to do, instead of defining what a trademark is throw out another trademark at you and let's see if we can figure this out together. And this is not a trick question, by the way, but let me know in the chat, who do you think owns Hakuna Matata as a trademark? Again, it's not a trick question. Yeah, you guys are on it. Yes, Disney owns Hakuna Matata. And if I could grab Kanisha or Gisette, if I could pull one of you through the screen and have you sit next to me and ask you what was going through your mind when you said Disney, you'd probably be saying something like this. Well, when I hear Hakuna Matata, I think of the song, which is in Lion King, and Lion King is owned by Disney. Everyone, that thought process is a trademark. We lawyers call that source identification. But a trademark is really nothing more than when you hear a word or a phrase or you see a logo, it makes you think of one brand in particular. And it just points to the fact that that brand has done a good job of saying, okay, when you see this thing, you think of this business in particular. Which brings us then to this next question. Okay, if that's what a trademark is, how do you protect it? But the first question here is, do you already have a trademark? And a lot of you might be wondering, Joey, why are you talking about this? Of course, I don't have a trademark, because if I did, I wouldn't need this training. Again, this is where trademarks are kind of weird. And to help explain this and break it down, I want to use this metaphor that's been helpful with our clients of a house versus a fence. Now, as you've got your business, think about it this way. The fact that you've created and launched your business means that you already have this house in place, but you don't really have a fence around it yet. In other words, you already have some trademark rights. You just don't have strong trademark rights for it. There's different types of layers of trademark rights here in the US. And a lot of people, when we talk about trademarks or getting trademarked, we're talking about this fence. But the truth is that you have trademark rights just by being in business. Just by being in business, you have this house. It's called common law trademark rights. And by the way, that's what that little TM symbol stands for. And that's great. It means that you have exclusive rights, but they're pretty weak. You only have exclusive rights under common law trademarks to your brand with respect to your geographic region. So bigger than a city, much smaller than a state. But these days, especially with the internet being what it is, almost all businesses want our brand to be exclusive at the national level, maybe even beyond that. But that's what the circle R does. That's what that fence is. When you apply for a trademark at a federal level, then you can use that circle R. It gives you, again, nationwide exclusive rights to not just your brand, but to anything that's confusingly similar. And again, that's the main difference between these two symbols. That TM symbol is short for those automatic common law trademark rights. And that circle R is a sign that you've done the filing, that you've got these national trademark protections. And cue the head explosion emoji, because that's usually the biggest takeaways that people have from this training, which is that you can use that TM symbol without having filed anything, without having paid for it. And I'm a huge fan, if you haven't already done so, go ahead and slap that TM on your business name, your logo, your slogan, whatever you've got, because a lot of people don't know this difference. And it can be a really strong deterrent to any of your copycats when they see that TM symbol. So that's a great free thing you can do to start to protect your brand. Said in another way, it's not really about getting a trademark. It's about claiming a trademark that you already have and are using. All right, this brings us to poll number 2 of the day. Are you currently making use of that TM symbol in your business and branding? Give me a 1. Give me a 2 in the chat if you're using that TM symbol already. And give me a 3 if you're going to start. Awesome. Okay, if nothing else, I hope that you guys all had that great takeaway from this training. Okay, so now let's talk about why trademarks. You don't have a strong proof of ownership without that registration. That TM symbol is great, but I like to think of when you apply for a trademark at a federal level and get it, that registration is like a birth certificate for your brand. It's easy proof if you ever have to prove yourself in court that you own it correctly. And it's difficult and expensive to defend and enforce your rights without a registration. Rebranding becomes increasingly expensive as your business grows. My team and I have done quite a bit of research on this, and the average trademark dispute can easily cost over $200,000. Plus, in terms of just brand building and kind of PR, it's a really great sign that you're legally legit when you can use that circle R symbol after your business name and things like that. I 100% believe, I stole this from my business coach, that your success as a business is inevitable, which means that problems are also inevitable. And without trademarks, you're just one cease and desist letter away from losing your entire brand. I can tell you that for a lot of the businesses that we work with, as your business is growing and getting a bigger reputation, it's a matter of when, not if, you'll get something like a cease and desist letter unless you take care of this stuff proactively. I'll say it again, a trademark dispute can easily cost over $200,000. So let's focus on solving this big problem first, which brings us to mistake number 2. I'll wait to handle trademarks later once my business gets bigger. All right, give me a Y in the chat for yes, if you've heard this before or said it to yourself. A lot of lawyers, by the way, who don't specialize in trademarks tend to give this advice, which I don't recommend. So if you are another attorney in the space, hopefully this can be a great nugget for you as well. Rick, good point. A lot of people are just unaware. But I'm excited to dive into all of this with us because I hear this quite a bit. I'll wait to handle trademarks later. And there's something that is almost logical about this that I want to speak to. The truth is that we have a problem. And to help explain what this problem is, I'm going to ask everyone to do something kind of weird. I want you, it's just a kind of a funny thought experiment. Imagine if all of the entrepreneurs in the world were jugglers in a field. So I live here in Chicago. I can look out to some big parks. Imagine that all the entrepreneurs got into one big park. And on the count of 3, they all started juggling their different brand assets. So their business name, their logo, their slogan. I want you all to get just a mental picture of the craziness that would look like. It looks something like this, right? A lot of stuff in the air. I shared this visual because I think in a lot of ways, this picture is more hard-hitting than this next thing that I'm going to show you, but it's equally important to be thinking about, which is, this is a chart from the trademark office. And this table, this chart shows the number of trademark registrations issued every year since 1998. And as we can see on this slide, the number, with a couple of exceptions, goes up every year. Quite a lot, from around 90K to almost 300,000. And I'll put that up on a bigger spot for the screen for you. So that's more than 250,000 trademark application registrations in a year. When my team saw this, when we looked at the numbers, we were really concerned about this, but we also knew this wasn't the whole story because this is just trademark registrations. Not every application gets accepted and registered. My team and I wanted to figure out in 2018 how many applications were filed. We found the number, over 500,000. That's a lot of applications to be submitted in just 1 year. The truth is that we are literally running out of trademarks. Things like business names. And there's a really strong chance that you're accidentally infringing on someone else. I say this because a lot of people come to me just assuming that the name that they want to trademark, they can trademark. But before we can talk about protecting the brand that you have, we have to have a serious conversation about availability. And that's why trademarks are a cost of doing business. And as early as possible, even if it takes you a while to file for your trademarks, you should be doing your due diligence as early as you can in your business to make sure that your trademark is available. Because if it's not available, you're already infringing on someone accidentally. Said differently, without securing your own brand with a trademark registration, you're taking a huge risk of infringing on another brand or at least being accused of it. Rick, you're right. Yikes, for sure. Which brings us to the third mistake. I did a trademark search and I'm fine. No one else has it. I'm just curious, give me a number 3 if this sounds like something that you've said or heard before. That you did some type of a trademark search and you're fine because no one else has the trademark. Okay, I'm seeing some 3s come in. So that brings us to this question of, is your trademark available? And I want to talk about this in a couple of different ways. You want to make sure that when you're at that naming stage or coming up with a slogan for your business, that you're looking before you leap. I think most of us know how to do our due diligence to a degree here. We all go on to Google, see if anything comes up. Maybe we grab the domain names, or we get the social media handles, or we even file for an LLC for that name. And those are all good steps, but your work isn't done. You also want to make sure that you're searching the database. Fortunately, a growing number of business owners are learning that this exists. If you don't know, there is a free database you can go to at uspto.gov. One of the resources that I have for you walks you through how to go there, but it allows you to run a free trademark search. You go to this website, it takes you a while. Eventually, you click on a couple of buttons and then you see what's on this screenshot. It's like the trademark office's version of Google stuck in the 1990s. It's a little clunky, but it's free and it works. And you can type in whatever word or phrase that you want to use, and it'll let you know if anything's taken, if someone else has it. And I'm curious, have you done a free trademark search before at uspto.gov? Give me a Y or a yes in the chat if you have, or an N for a no if you haven't. All right, great. We've got a smart crowd here. So I'm getting some yeses, some nos. If you're saying no, again, this is a great takeaway for you to know that this database exists. Very, very, very helpful. But again, I wouldn't be doing my due diligence as an attorney if I just stopped there, because we also want to consider this likelihood of confusion trap. You see that free trademark database, it's great that it's there. It's nowhere near as smart as Google. And you also have to be thinking about what I call the likelihood of confusion trap. So what I put on the screen here are all different examples of a company applying for a trademark for a certain name. And I bet you that when they searched the trademark office and they searched for their name, nothing came up, because that specific thing didn't exist on the trademark office. And yet the trademark office denied their application, not because it was the exact same as this other trademark, but because it was confusingly similar. This confusingly similar thing is a concept that we don't have to worry about when it comes to domain names or social media handles, or even getting something like an LLC, but we have to be mindful of it when it comes to trademarks, because the point of the entire trademark process is the trademark office has thousands of reviewing attorneys who review your application. They actually get paid to find some reason to deny your application. And one of the biggest reasons for a trademark to get rejected is because it's too similar to another trademark. This frustrates a lot of business owners, but I want to highlight this last example because I do want to show you that there's a reason for this. A lot of you are probably familiar with the company Blue Apron. It's a food subscription box service. It sends groceries to your house. So they own Blue Apron. Another company tried to apply for Green Apron and did not get it. It got rejected. And that kind of makes sense, right? Like, as a consumer, if you found out about Green Apron, you might think that, oh, maybe that's Blue Apron's like all veggie line, or like it's their more sustainable box. It can create some brand confusion and make you think, oh, is Green Apron a spin-off of Blue Apron? Are those brands connected? If I buy from Green Apron, am I expecting that same service and product that Blue Apron offers? Maddy, you're right. There's a green chef too. I say that because the company that tried to get Green Apron was Starbucks. It makes sense now that we see these pictures that, yeah, Starbucks has Green Apron. But I think that the trademark office made the right call there. I do think that that would have created quite a bit of customer confusion if there would have been a Green Apron in the marketplace in addition to Blue Apron. Yes, Starbucks got rejected, Maddy. But I wanted to highlight that example just to show the line of reasoning that the trademark office has, and how, as frustrating as these rules can sometimes be for business owners, there's good reason for it. So that was that likelihood of confusion trap. And then finally, I want to talk about this: to take action after you've searched. I want to bring all of our attention again to that boring but important table from the trademark office. Again, over 500,000 applications get filed every year. I cannot tell you how many times we've worked with business owners who paid us to do the search. And then for whatever reason, it took us a while to get the application out there, to get the application submitted. And unfortunately, there have been times where by the time we actually, or the client wanted to move forward and file their application, someone else moved forward with it. This is one of the biggest mistakes that I see smart, savvy business owners making, is forgetting that that search that you run, even if you run a good search, even if you think about that likelihood of confusion trap, that search that you run has an immediate expiration date. Someone could file the next day, and that search that you ran isn't going to help you. So really, really consider getting that application filed as quickly as you can after you run the search. That's why my team and I are as mindful as we can about getting that application submitted within 2 weeks of when we completed the search. Okay, I know that was a lot, so I want to do a quick recap of these mistakes. And if you know your keyboard shortcut for doing like a screenshot, this is a great one. Again, I'll show you guys how to get these slides at the end, but get those screenshot fingers ready. I'll tell you when to use it. So mistake number one is I don't need a trademark because I already have a fill in the blank. But the truth is that you don't own your brand without trademarks. And that circle R symbol, that registration, is proof of ownership at a national level. Mistake number two is I'll wait to handle trademarks later once my business gets bigger. But the truth is that trademarks help ensure that your brand is even available in the first place, that you're not an accidental infringer. Mistake number three is I did a trademark search and I'm fine. No one else has it. The truth there is that comprehensive searches are tricky to do and they expire immediately. This is the screenshot part. This is a great slide just to have as a takeaway so that this can be a good reminder for you as you're keeping your brand protected moving forward. And I'm a huge fan of keeping things simple. So I tried to one up myself, said even more simply, number one, if you're growing, you need trademarks. Number two, you need to make sure that it's available. And number three, you need to take action after you've searched. The big takeaway here is that without trademark registrations in place, you're putting your business at risk of losing its brand recognition or letting competition steal from you without recourse. So it's critical to call dibs as soon as possible. That circle R can be yours, giving you the confidence of knowing that you own your brand, that you're proactive on the legal side instead of reactive, that you actually understand the process and significance of all of this, allowing you to call dibs so that others can't take what is special sauce for you, and using domains, accounts, and business names without fear. We are literally running out of, again, trademarks, business names. Think about that likelihood of confusion trap as you're running these searches as well. And think about being Lindsay, something that I think when we talked about earlier, that thought exercise, it would be a really big relief to read this and say, yep, that's me. That you're proactively applied for trademarks, that you don't freak out, that you can go to bed easy at night, and that you can handle copycat situations objectively. Okay, last poll here. What steps are you going to take now that you've watched this webinar? Give me a 1 if you'd like to reach out to Indie Law or to a trademark law firm to figure out any next steps to protect your brand. Give me a number 2 if you're going to do some extra research on your own. And give me number 3 if you're thinking, thanks, Joey, this was helpful. I'm not going to worry about this for a while. I hope that's not the case, but we can be honest here. Okay, I'm getting some 1s, I'm getting a 2. Honestly, I don't care what your answer is here. I just want to help everybody get off of the decision fence. I think it's really helpful after watching a training like this to figure out what action, if any, you're going to take, and then commit to whatever that action is. A little bit more about Indie Law. So like I said earlier, one of our slogans is that we put the rad in trademarks. We say that because we actually have a signature, we call it rad strategy. The R is short for ready, where we review the trademark application and compare it to others for any red flags. Aim is where we strategically prepare your application for a successful registration. And then D is for done, where we submit the application and do all of the heavy lifting for you. Again, our team does all the heavy lifting. As you relax, we'll take care of you throughout the process, and it's all flat fees, so you never have to worry about hourly rates. If you're ready to book a free brand protection call with us, you can do so after this. So I mentioned at the very beginning of this training that I've got these deeper dive resources for the action takers. Again, if you decided that you want to reach out to a lawyer or just to learn more, here's a great action step for you. I've got 2 high value bonuses for you. And Maddy, if you could put this in the chat for me as well, but you can just go to www.indielaw.com/bonus. It'll take you to a short little questionnaire, little survey, getting a sense of what you got out of today's training. It shouldn't take you more than 3 or 4 minutes to complete. So I can, while I'm going through the questions, would love for everybody here to go through that. It's really helpful for me, for Maddy, and for Smith to make sure that we're doing as good of a job as we can during a training like this. And then after completing that resource, or after completing that form, that survey, you'll get these bonus resources emailed to you. All right, Maddy, now we can get started in the Q&A.
Awesome. All right, great. Well, we've got a bit of time actually, so I think we'll be able to get through most of these questions, but feel free to keep posting them in the chat and I will keep an eye on them.
Perfect.
So starting with the oldest, and for some reason, I'm sorry if you're not able to copy those links in the chat, just type in indielaw.com/bonus. Thankfully, it is a short link and we will figure out how to fix that in the future. So Gaetano asked a question about cannabis brands and how do you protect it? I don't know if there are specific considerations, Joey, considering the state of, cannabis and legality across the US, but is that something that you want to share any knowledge about?
Yeah, well, I can say as I was doing the training, I was keeping an eye on the chat, and we've got a really smart group here. These are all really, really good questions. Yeah, if you are in the cannabis space or at all curious, please email me. Not to keep asking Maddy to dropping stuff, but you can email me at joey@indielaw.com. I would love it if you reached out to me, because the truth is that IndyLaw is a trademark only firm. There are people with an even deeper niche that I would love to connect you with. There are firms that specialize in cannabis trademark law. And Maddy, you're right. Just with the state of cannabis law, the fact that it's not yet legal in all 50 states means that we have to be very, very careful in filing for trademark rights for these things. In a pinch, IndyLaw can do it. But honestly, I would want you to be in the best hands possible when moving forward with something like that. And the laws are changing so much. I've got some great referrals that I can connect you with if you'd like to move forward. And I would recommend it because there is a line of businesses that are ready to move forward quickly with trademarking brands in the cannabis space. And so it's really important, especially in a spot like that, to make sure that you don't put this aside and then not worry about it, because it's getting very competitive naming wise, to make sure that you're coming up with a name that's not already taken or similar in the space. And the cannabis trademark lawyers and firms that I work with are really good about making sure that you're taking the right next steps. It's a weird line you got to dance between protecting your brand and not just raising your hand to the federal government that you're doing something illegal.
Right, definitely. I think those are considerations that are top of mind.
Yes.
And actually that even might relate to something that is an established brand of 100% legal across every state that might want later to introduce, cannabis products, right?
Yes.
Like there might be a restaurant or food service or food product that is doing things that have no cannabis, related. And later on, maybe next year, they're going to add cannabis products to their product line, then
Such a
what?
good
So it's a
point.
consideration if it isn't already something affecting your business, if you see it in the future.
Yeah.
Probably.
And again, I don't want to speak out of turn here, because a lawyer who has a specialty in or a focus on cannabis law might give more specific nuanced advice around this, but it is possible to apply for an intent to use trademark application saying that your business doesn't yet use that brand in that way. But to your point, if you're a business that's thinking about these types of products, it might even be possible for you to file those applications under the advisement of counsel, even though you have not yet started that type of product line.
Got it. That makes sense. So next question from Rick. What if several businesses all have the same name in different states? How do you approach trademarks in that sense?
Yeah, I want to answer this in a couple of different ways. One is that when I talk about those different layers of trademark rights, one of the layers that I didn't get into is state-specific trademark rights, where you file not for a nationwide trademark, but a statewide trademark. That is possible to do, but is increasingly something that fewer and fewer business owners do, to the point that I don't even talk about it anymore unless someone asks about it. To that extent, though, because of that, and because trademarks are mostly seen as a federal thing now, there's less of a discussion about state-specific questions around trademarks. But to answer your question in a different way, it is very possible for different brands to have the same or similar name, as long as it doesn't create confusion in the marketplace. So there can be,
consider them different marketplaces. Basically.
Yes. So there can be Delta Airlines and Delta Faucets. Okay.
But Delta law firm in Tennessee versus Oklahoma.
That is not, if you were in one state and you saw a firm in another state with the same name, I would advise caution and maybe consider a rebrand.
Great. That's super helpful. Maybe it also depends on proximity, practice area, et cetera. If it's a trademark firm and you're practicing nationwide, then, obviously you're going to have some troubles there. Okay. So, and then Rick had a follow-up question, and then we'll move on. What if they're not trademarked? He says, can I have them rebrand? So there's some control you might be able to exert here.
Again, it goes back to that idea that a trademark is created. Trademark rights are created upon use, not upon filing. So it doesn't matter really. So start using the paperwork first. It really matters who started using that brand first. So we do have to advise, and this is a difficult conversation, but if you see another brand that has the same brand as you and they haven't filed for any trademark rights, it might be tempting for you to beat them to the punch, to file your own trademarks. But if you know for certain that they've been existing longer than you have, and
a strong case there.
And it's not a strong case. And not only not a strong case, but you're basically lying when you're lying under oath when you submit your application, where you have to say, I believe and in good faith declare that I was the first to use this brand name in interstate commerce with respect to my audience.
Okay. Yeah, that's extremely helpful. So Barry asks, isn't it true that scalpers, quote unquote scalpers, can see your search and register that name to capitalize on it? I'm guessing trademark search.
Potentially,
or see you in search.
Potentially, yes and no. That's something that we probably see more of in like the domain.
Yeah, I was going to say the land grab domains.
Maybe social media sites. I haven't heard of any software or companies that are able to do that at the trademark level. But again, trademark rights are created upon use, not upon registration. So even if that technology existed, you can't.
It wouldn't be justifiable. They're not
right. A trademark will get rejected unless that company can show use. So the trademark office, yes, it can be frustratingly difficult and long for you to get your applications registered. But the good side to that is that scalping isn't really an issue.
Not a viable threat.
Right.
Okay, well, that's comforting. All right, so how much, that's my own question. I'll save that for later because I want to make
Okay.
sure that we get to the participant contributed ones. Okay, William asked, can someone get off the supplemental register and onto the principal register after 5 years or more of continuous use?
That is a very intelligent question that's probably over the heads of most people in this audience, but I will just say yes.
Great. Aaron asked, what is the impact of a dead designation in USTPO on a trademark application?
Love this question. So many people get tripped up by this. When you run a search at the trademark office, if there are any results that get hit, it gives you this like spreadsheet looking itemized list of trademarks that fall under what you searched for. And it'll give you some numbers. You can click on some links and it will always say either live or dead. You have to be very careful about what that actually means, because I first want to cover what live means. Live can mean one of two things. It either means that it is a registered trademark or that it is an active pending application. So just because you see live doesn't mean that that company owns it or that it's taken. You want to do your due diligence to make sure that you see a registration letter. You'll also see you'll see two sets of numbers. So if it has a serial number, all applications have a serial number, but only registered trademarks have a registration number. So just be careful when you see live. And then dead means that the application was never registered and it was denied, or at one point it was registered, but it's no longer registered. Again, all of this is paperwork with respect to the registration, not necessarily the underlying trademark rights. So again, usually if you see dead, that's a good sign. But if you know that there's a brand out there that owns and has been using this thing, and maybe for some reason they missed their renewal fee, just because it's dead doesn't mean they no longer have any rights. And if you know that they were using this before you, that they're still using it, proceed with caution, because they're still the superior rights holder. They've just, again, lost that like birth certificate proof of ownership of their trademark. Right.
And bear in mind, they've been using that a lot longer than you have. Right. So there's a precedent there.
Now, if they're no longer using it, now it opens back up.
Does it reset, Joey? Like if you stop for a period of time of using it, do we assume that you have relinquished sort of use of that to some extent?
Usually, yeah. So that's a really interesting hypothetical. But let's just to give kind of a stark example to that. If I applied for a trademark and got it and stopped using it, and then it was canceled and shown as dead, and then Maddy started using it while I wasn't using it, I can't just start using it again and like try and reclaim it back to you and claim my earlier first use. The fact that you used it and are now using it, and you started using it in that period where I wasn't, now you have superior rights.
Okay. All right. That's really helpful. I think, there's also with any small business owner or entrepreneur, this fear that your brand isn't quite set up the way that you want it to be. It's not perfect. It's not, man, are you sure that that's going to be your business name, before you go ahead and, start protecting it. And that can delay a lot of good decisions.
Well, so, and if I can quickly share a horror story,
please.
It's not something that I love to do. I'm a positive guy, but this stuff's important. So one of our clients, and you guys can all picture this, imagine that you're about ready to start your family vacation. Like you've been in business for a while. And this is the time that you've been looking forward to closing the laptop to being with your family. And as the plane touches ground on whatever it is that you're spending your family vacation, you swipe your phone off of airplane mode, you check your email inbox out of habit, and you see this big subject line that says cease and desist, saying that you have 30 days to change the name of your business. That happened to one of our clients. And something that we try and educate people as much as we can on is this idea that flat tires never happen in opportune moments. And more often than not, when you get blindsided by something like a cease and desist letter, it's going to happen when your hands are already busy. When you were looking forward to something. And my team is just really dedicated to making horror stories like that happen as little as possible.
So protection, not perfect, right? I mean, if you're already operating under a business name, protect it and deal with your future perfect state when you arrive at it.
Yes, yes.
Right. Great. Joey, thank you so much. There's a final question and then I think we'll wrap up. Do you have a link for referrals? There's a request for sending your information to others. So
I appreciate that.
Joey.
We don't have a link for referrals, but we do have a process that we love for sending intro emails for referrals. So Ashley, if you email me at joey@indielaw.com, I can send you those materials. We'd love to collaborate with you.
Awesome. I am putting that in the chat. Thankfully, it's nice and short. So sorry if you can't copy it, but type it down in your notepad. Okay, wonderful. Well, everyone, thank you for being here. Joey, you are a hero as always. Thank you so much, everyone. If you have not already checked out indielaw.com, go and do so. indielaw.com/bonus. Get those resources, take advantage of this free consultation. I mean, Joey's business has exploded in the last few years. I mean, he was already on a really successful track. So who knows how much longer he's going to continue making these offers. I don't know how you already have time for this, Joey, but thank you for being here. And thank you for sharing all of this wisdom with us and you know, gracing us with your time. It really makes a huge difference in our lives to protect our businesses. So you know, hope to see you again soon.
It's a pleasure to be here. I never pass up an opportunity to hang out with Maddy. You guys have been such a great, engaging audience. Thank you so much. And especially to all of you who came here live. It was great hanging out with you all. Hope that you've got some great takeaways and golden nuggets you can walk away with to keep your brands protected.
Absolutely. All right, wonderful. Take care, everyone. Thank you.